Welcome back, friends, to the Probate Nation, especially our returning viewers from the state of Delaware. My name is Richard Ruddy. Tonight we will learn how Delaware assets owned by a deceased person who lived in another state, or for that matter in another Delaware county, are probated through what is referred to as ancillary probate. Probate is very much like traveling on a slow-moving steam engine train, which calls to mind the train trip many years ago of the famous U.S. Supreme Court Justice Oliver Wendell Holmes. When approached by the conductor who was confirming the passengers' tickets, Justice Holmes, reaching through his pockets of his jacket, could not find his. The conductor, recognizing who he was, said that that was not a problem, but Justice Holmes was more concerned about not whether he had purchased a ticket, which he had, but he needed to know where he was going. We are fortunate to have back as our guest Veronica Townsend, a Delaware probate attorney who knows all about ancillary probate. She will share critical steps to be addressed and stops to be made in the course of any Delaware ancillary probate journey. But first, let me tell you about Veronica. Veronica is a proud, lifelong Delawarean whose family roots in the area trace back for many generations. She is a graduate of the University of Delaware and the Elon University School of Law. She is the owner of Delaware law firm Wyndham and Townsend. A large portion of her practice is focused on estate planning, probate, and state and trust administration. Her passion is to serve her local community by rendering advice to her clients that helps them achieve their wishes in taking care of their loved ones, and by being a guiding light for them in difficult times. Veronica, welcome back to the Probate Nation.
Hello again. Great to be back.
And we appreciate you taking the time again. We're jumping into ancillary probate. Tell me, what is ancillary probate?
Ancillary probate is a secondary probate. So the word ancillary implies that the estate of the deceased has already been probated or will be probated in another state or county, but they owned an asset that was in our particular county. So it's a secondary estate that has to be handled in Sussex County.
And what assets do you typically see that need to be probated in Delaware by a non-resident decedent or someone from another adjacent county?
I would say that 9 times out of 10, it is a property in our county that the deceased had as a beach house. Our area is a very large tourism industry because we are right by some of the most beautiful beaches on the East Coast. So oftentimes, I'm a little biased.
And so that's an advertisement for the
Come visit Southern Delaware, yes. So oftentimes it's somebody that lived full-time in surrounding states or DC, Virginia, Pennsylvania, or even Northern Delaware. And it's very common for those people to own a beach house in our area. So typically that ancillary estate is being filed because the deceased owned in one of those surrounding states, but they had a beach house in our county.
So that's really the trigger that would otherwise trigger the need for ancillary probate is owning a piece of real estate, or in some cases we talked about some mobile home situations can also be a way to trigger that as well, from what I understood. Who would typically be the person that would undertake the ancillary administration?
It's most typically the executor that's handling the estate in the primary state of probate. So the executor that's taking on the probate for, let's say, Maryland, they're going to be the ones that are taking care of filing the documents here in Sussex County as well.
So we had a nice conversation in an earlier show about regular Delaware probate. So are there different options available to probate to undertake an ancillary probate in Delaware?
There's really one type of ancillary probate. However, I have had some clients over the years that passed away as a resident in another state, but their estate did not necessarily trigger the need for probate in that state.
Mm-hmm.
So what happens in those situations is if there's documentation that that deceased lived in another state but did not formally own a real asset there, let's say they had a revocable trust set up and their trust owned their house, all their bank accounts had beneficiaries on it, but they still owned a house in Delaware in just their name. It's not an ancillary estate because there was no first estate that was ever opened. It then ends up being a full probate in our county.
Okay, well, that's good to know. So what court oversees Delaware probates?
In our state, it's our Register of Wills office.
Mm-hmm.
There's the Chancery Court, which is a Delaware-specific court that handles corporate matters like corporate litigation, as well as estate litigation too. Okay. So that's a very special Delaware court that other states do not have.
Now, we sort of talked about this, but What assets are typically the subject of ancillary probate? When we talked about that, I know we have real estate, but you mentioned a couple other things that I find kind of interesting that might also
Absolutely.
might also be considered real estate. I wouldn't have thought of that right away. Can you talk about
Yeah.
that a little bit, please?
So sometimes I will see some bank accounts that clients owned in our states, but primarily with the real estate front, it's either owning a full interest in the land and the home that's attached to it. But our area too is very big when it comes to mobile homes. Again, a lot of times people will purchase them as their beach fun investment type of properties. But many times, the way that the property is set up, they will have a deed for the land itself, and the mobile home will still have a true title that's issued from the DMV, just like with a car.
Oh, really?
So in those situations, it can be a mess when you have your deed and your title for the mobile home itself. And in order to clear title for that mobile home, once someone passes away, you really have to ensure that ancillary estate is filed, because it ultimately is a trip you have to take back to the DMV to get that title transferred over to the heirs under the will.
Wow. Very interesting. I didn't, when the mobile home thing was very interesting when we were working on preparing the show. I was quite fascinated by that. What is filed? We're trying to get started with, probating, but what's filed with the Register of Wills to initiate an ancillary probate?
Ancillary probate document wise is very simple and straightforward. So all the deceased, well, not the deceased, all the executor needs in order to file with our Register of Wills office, they need triple sealed, exemplified copies of the opening probate documents that had been filed in the other jurisdiction. So again, with the example of the deceased living in Maryland, that executor will need triple sealed documents from the county in which the person died in Maryland from their Register of Wills office to submit to our Register of Wills, proving that that person had passed away and proving who the executor is. In addition to those documents, you also have to file an ancillary inventory. That is where the executor has the chance to list what the deceased actually did own in Sussex County, and then pursuant to their will or to intestacy, where that asset passed once that owner died.
Now, when the person gets qualified and they start this process, is a bond going to be required, a bond with surety insured by an insurance company? Is that going to be required for that ancillary probate?
There's no bond requirement, as well as the creditor claim period requirement that's typically in place with a full probate. There's no creditor claim period and requirement with an ancillary estate. So no bond, no creditor claim, really just the opening documents from the other Register of Wills office and the inventory that's required.
Now, when I filed the ancillary probate application, do I have to have a local attorney listed to receive service of process for someone who's an out-of-state personal representative?
That's a good question. No, there's no need at all, no requirement for anything to prove that you're represented by an attorney or that you have somebody in the state to receive service of process.
So
They do not require that.
is the same process as for regular probate, that basically we file an affidavit saying or power of attorney appointing the Register of Wills to receive service of process?
Not even the need for that. Nope.
Really? Very interesting. So you talked about this, I think you mentioned this, but if someone did as you had just suggested, they home state of Virginia, they fully funded, we see it all the time, okay? Fully funded, we tell them you need to get that Delaware real estate transferred, or you need to do that in this particular state, and they don't do it, okay? So at that point, there's no home state probate. So I gather from our conversation then they would just undertake a regular probate at that point for that?
It would be a regular probate. And I've had to do a few of those in the past and one recently too. And it's certainly a challenge because oftentimes that executor is not familiar, with our area at all. It might have been a family property and everything else was titled in the name of the deceased and their spouse, or the deceased and their kid, or their revocable trust. And it can definitely be a challenge if then they have to do a full probate for the asset in our state logistically. But paperwork wise, it still is not that complicated if you just know that they owned one asset here that you have to probate.
Okay. Now, once I start the ancillary probate process, what can be done with the real estate? What can the ancillary administrator do with the real estate once they've filed their initial paperwork?
So once that inventory is filed, the executor is able to sell the property if that was the wish under the will, or they're able to then have it transferred out of the estate and over to the heirs that are listed under the will. In our county in particular, when the inventory is filed, that puts the Register of Wills and our county tax assessment office on notice that the owner of the land died, and pursuant to their will, there's new owners that should be listed of record. That alone often negates the need to get a new deed prepared at that time, but I still have many clients that call us, and we still do recommend to get a new deed prepared at that time anyway, just for simplicity, and so you know everything is all broken down properly, and you're really looking forward ahead to, if you ever sell the property, that everything is already documented.
Okay. Let's turn our attention now to, we've talked previously in a regular probate, the duties of a regular administrator, personal representative, but what is an ancillary administrator? What kind of duties do they have?
The duties are somewhat similar. You still have the fiduciary duty to the estate to honor the wishes of the deceased and to be sure that their assets go to the people that are set forth in the will, and to ensure that you are representing the interest of those beneficiaries and to ensure that they get those assets that they were intended to receive.
Now, is there an obligation, again, this is an ancillary administration, do they have to file an inventory?
They file the inventory, but you can file it right away once you file those opening documents. It is not like a full probate where the executor has a 3-month window to gather all those documents and get them together. They don't have to wait even the 8-month period for creditor claims, so you can complete everything you need to with an ancillary estate, even just with one filing.
Yeah, and now that's interesting because now do they have to file an accounting at all?
They do not need to file an accounting. There's no need for that with an ancillary. So it's just opening documents, ancillary inventory. Once those documents are filed, that executor no longer has to worry about the Delaware probate, ancillary probate.
Now you mentioned them. If we're jumping into the creditors, because we're always worried about creditors, and we're worried about somebody showing up saying we owe money or whatever. Ancillary probate, is there any sort of notice, publication of any kind like that to give creditors notice to make claims?
There is no notice. I believe the intention on that one is if it's a true ancillary probate, it's already being administered in another state, so the real creditors would receive notice from that primary probate. But there's no notice that's given to creditors with an ancillary.
Okay. Now, well, we've gone through a lot of steps. We've got qualified. We filed our paperwork right away. There's no accounting, so there's no creditor notice. I want to just kind of wrap my work up. I mean, how do we close this estate, or is it already closed? For all I mean, it might be.
Everything is closed. Again, you can accomplish it all just with the one filing, the opening documents, listing that inventory. That accomplishes everything you need to. There's no notice or any letter that you have to then give the Register of Wills telling them that you're closing it. You really open it, but close it at the same time with those documents.
That's so interesting. Now, what is the typical, this I think I know the answer to my own question here, but what is the typical timeline from beginning to end for a normal ancillary probate?
Normal ancillary probate, typically just a few months, and that really just depends on how quickly the executor is able to get the exemplified copies from the other state or other county's Register of Wills office, and the time that it takes them to list that inventory. It can take a couple weeks if there was real estate that we're dealing with, because they should get it appraised by a certified appraiser in the area. So those are the outside factors that you really have to worry about. But otherwise, the timeline is really just set by the executor for when they can get everything signed and filed.
Now, in that regard, as far as getting it appraised, you mentioned, I think, when we interviewed you in a prior show, that the Register of Wills collects a percentage of the asset values as a fee for their work, which they provide a great service. Do they do the same thing with the ancillary probate? Do they take that same fee at the end or when the initial filing's done?
That's a great question. So our state and our county, they do not take a fee for any ancillary work. It's something that I've had the conversation with many clients over the years, because at the end of the day, we want to make their lives as simple as possible on their executors, but many times too, making their lives easier, it means helping them save money. But with ancillary, there is no additional fee that you have to worry about. Basic filing fees will be imposed when you have to file that set of documents with the Register of Wills, but there's no net closing fee that they impose.
Very interesting. That's really good to know. Now, in the case of Delaware real estate owned by a non-resident decedent, and we've been talking about ancillary probate, but it always sort of raises the question, what could they have done to avoid a Delaware ancillary probate of real estate in the first place?
So the few instances that I have seen where a ancillary estate or even a full probate was required here, the deceased owned a property in another state or another county and they had a revocable trust set up. But when you have a revocable trust, every piece of real estate that you own needs to be owned by you as trustee of that trust. So some of those instances in the past, I had a deceased who had a trust set up in Maryland. They had their Maryland real estate titled in the name of their trust, but they never took the step to get their Delaware property retitled in the name of that trust. So always take a look at your deeds. If you have a trust that's created, that trust needs to be the owner on all of the real estate that you own.
You know, I tell you, it is so important. I mean, that's probably one of our big mantras is avoid probate, fund your trust.
Absolutely.
Probably the review process with our clients most often has to do with that very thing. Show me the bank statements. Show me the whatever. Have you done this deed? Have you not? I mean, so very, very important. Now, with a lot of people who, because of telecommuting, has become a very popular thing and an accepted thing. A lot of folks are selling their houses in Virginia, okay, or Maryland, and heading to the beach, okay, and taking up and making Delaware their residence, okay. You know, but when they move there, that comes into, you know, what comes into, what's a concern to us is what do we do about all those great documents that I prepared in Virginia that were fantastic, of course, but now they're in Maryland. I mean, now they're in Delaware, I should say, pardon me. Let's just talk about the types of documents and what you would suggest be done. So the first one I think that comes to mind, if I don't have a revocable trust, I have a will, or if I do have a revocable trust, I'm going to have a will. How important is it to redo that will, especially if they don't have a self-proving affidavit?
Absolutely. So whenever I have clients that move here from other states, because again, this area is growing so much for that reason, everyone wants to come to the beach and everyone wants to retire here. So just because you had a will done in a surrounding state, if you do make Delaware your home, you really need to meet with an attorney to get it updated to ensure that the witness and notary requirements are sufficient in our state. So many times too, when clients that I meet with are moving here, that will is just due for an upgrade anyway. They've sold their house, they bought a new house, they've had grandchildren. There's just many years that have passed since they signed that first will. So it certainly is a good time to get it updated. Once that person moves to our state, if they already had a revocable trust that was created, we discuss everything at their intake appointment to determine if we're able to keep that trust intact. Perhaps we can do a simple amendment to it just to reference that now Delaware is the state law that governs the trust, but otherwise all the content of that trust is the same. It just depends on what the wishes are for that person. But we also go through, even to the point about real estate earlier, we discuss all of their assets and we ensure that that trust is the owner on the real estate. If they didn't put their Delaware property in the name of the trust, we will put it in it right at that appointment. So we go through all the assets then just to be sure that not only their wishes are fulfilled, but if they have a trust, everything is funded in the trust, and that the Delaware laws appropriately govern what will happen with those documents.
I think that's important because we certainly have told clients that when they move to another state, whether it's North Carolina, South Carolina, Delaware, wherever it may be, that the trust is still good. The problem is that if they want to get advice about that trust, you know, the lawyer in Delaware is not a Virginia lawyer, so they can't give you advice about Virginia document. But if you turn around and amend that and make the law the trust governed by Delaware law, now they can have a conversation about how that trust works in Delaware. And I think that's
absolutely.
And that's an important thing that you make the point of. So you may not have to redo the trust, but you know, again, things may have changed which would require an update, and that certainly is a good time to do that. Now, the two documents that I think create the most challenges and absolutely have to be updated, in my opinion, is the financial power of attorney and the advanced medical directive. These are great documents. We have really powerful documents, but they're written, especially the medical documents, are written under Virginia law. You know, so if I show up in Delaware with a medical decision-making document at some nursing home or hospital, those people are going to start scratching their heads saying, what is this? So what's your thought about that? I mean, I would almost insist that they get the power of attorney and and medical document updated. But what is your thoughts about that?
I agree with you completely. Those are always documents that I update every time whenever someone has moved here from another state. To your point about the laws in Virginia, same in Delaware, there's a breakdown of what powers you can give your agent, and they vary in every state. I've seen powers of attorneys that vary as far as when it's actually effective.
Mm-hmm.
The power of attorney that we sign with our clients in Delaware, you can choose to make it effective immediately or only if you're incapacitated. Sometimes people prefer that second option, so they're not giving all rights and powers away right now. And I've seen many other out of state powers of attorneys that make it effective right away, where that principle giving other people the power might want to change that.
Sure.
So I agree with you completely. That's always a set of documents that we update whenever people move here.
Sure. Well, certainly in the case of husband and wife, generally, I think a lot of times they're co-trustees of the joint trust. So giving each other the immediate right to handle the financial power of attorney is certainly something that wouldn't give me pause. But you always have to ask the question, though: do you really trust the people like your children?
Exactly.
Down the line, if you do, great. But that would be your call. So you may want to make that a condition precedent that some doctor says you can't make decisions for yourself, but that's a conversation that they should at least have. I mean, and they can make the decision because it's their decision to make. Well, we're sort of winding down here, but we have a little more time than we had before. So, can you share with our viewers some of the lessons you've learned over the years regarding the ancillary probate work that you've been involved with in Delaware?
So, ancillary probate, it really is so important to have a full picture of what you own when you're setting up your will and to properly take care of retitling property. So that way, if you do have a trust that's set up, we're making the life of your executor as easy as possible, because dealing with one state's probate can be enough work on its own. But when you're talking about other states' laws and having to cross state lines to administer things, we really don't want that executor to have to take on more work and time and travel that they need to. So I've seen it also happen where somebody passed away in another state, they left property to a family member in our state, and that family member ultimately passes away, or we have to do some estate work because there's been many inheritances involved with some properties. So again, just taking care of everything as timely as possible once one family member dies will be the most simplistic on the rest of the family for years to come.
That is so true, and I have that particular situation right now, which I started to have a conversation with you about that. So I'll return to that to you at a different time. But let's go now and get some of your final words of advice about steps to take and pitfalls to avoid in undertaking any Delaware probate, whether it's for a resident or a non-resident, whether it's ancillary administration or regular probate. Just some final words of advice and words of caution you might want to share with our viewers.
The biggest thing that I really want everyone to know, especially since my practice also handles real estate law, is if you have an open estate. So let's say that you are the executor, you have a few siblings, and your mother passed away and left you a home in our county. If that estate is still open and that creditor claim period is ticking, once you get the necessary documents from the Register of Wills to open the estate, you then have the authority to sell that house, but you will not get paid by the attorney's office that's doing the closing to give you your proceeds of sale until that estate has formally been closed out. So it's really good to be aware of that going into the process, because the process can take a while, can take around a year. So it's good to go into it knowing that those funds will not be dispersed right away. So don't go on a shopping spree, don't go to Vegas, don't go to Atlantic City, just hang tight until that estate has been closed. And it's really helpful too, again, if you're even getting a realtor involved to help you list your mother's house for sale, that it's a realtor that's really experienced with representing estates, because that's always something that they should advise you on once you're listing that house with them.
Sure, and that's a very good point. We have a similar thing in Virginia. It's actually a one-year clock that we can't disperse the funds unless we want to pay a fee in order to do so, but we generally tell the clients not to do that. Well, look, it's been great to have you on the show for Ancillary Probate again, and to get your insights and to share your experience with our viewers. It's a great public service. Your advice, of course, is extraordinarily helpful, and we are blessed to have you on here, and all the Probate Nation is grateful that you showed up today and were able to share this with us. So thank you again for visiting with us.
Absolutely. It's been a pleasure.
Without a doubt, and probate is and certainly is complicated and can be confusing. Veronica Townsend was giving you an excellent introduction to the ancillary probate process in Delaware, including forms that are available online, steps to take, and pitfalls to avoid. If you heed this advice, your ancillary probate train ride in Delaware should go a bit more smoothly. But notwithstanding all of the great information that's available, I would be remiss if I did not emphasize that handling any probate, ancillary or otherwise, pro se without an attorney is not something that I encourage. While there are exhaustive form documents available, the guidance of an experienced probate professional at the outset of your journey will help you avoid unnecessary work, delays, and additional fees and costs. This concludes our show this evening. Just a reminder that replays of this show can be viewed on the Probate Nation website and YouTube channel. And if you want to receive the monthly estate administration and probate tips newsletter, we welcome you and invite you to sign up for the free Probate Nation newsletter at probatenationnews.com. Thank you for visiting with us. Until next time, I am Richard Ruddy, and this is the Probate Nation.